legal system has spoken, and the message echoing from the Court of Appeal in Abuja today is chilling. You can torture a man, you can starve him, you can deny him medical care for years, and if you simply move him to a different cell before the judgment is read, the court will wash its hands of the matter. If you are watching this, you are witnessing one of the most controversial ends to a human rights battle in Nigerian history. The headline you saw is not an exaggeration. It is the cold, hard reality of what happened on Friday, November 28, 2025. The Department of State Services, DSS, has effectively gotten away with the years of alleged abuse against Mazi NNAMDI KANU, thanks to a single word uttered by the justices: academic. We are broadcasting this special report to break down exactly how the Nigerian judiciary used the technicality to bury the cries of a man who spent 4 years in what his lawyers described as a dungeon. And we are going to look at the specific allegations of torture that will now never be judged, the courtroom drama where his own lawyer was forced to seal the deal, and the terrifying precedent this sets for every Nigerian citizen, because this is not just about NNAMDI KANU, this is about the question: where is justice? On the morning of Friday, November 28th, a 3-member panel of the Court of Appeal, led by Justice Boloukuromo Moses Ugo, sat to hear the appeal filed by NNAMDI KANU, which was not about his terrorism charges but about his human rights, a suit demanding 1 billion naira in damages, and an apology for the cruel, inhuman, and degrading treatment he suffered while in DSS custody. But instead of looking at the evidence of starvation or medical neglect, the court looked at his current location. Justice Ugo delivered the lead judgment with a statement that stunned the courtroom when he declared that the appeal had become academic, effectively saying that what KANU was asking for had been overtaken by events. The judge reasoned that since the primary relief sought by KANU was to be transferred out of the DSS cell and into a regular prison, and since the Federal High Court had already convicted him on November 20th and ordered his transfer to a correctional center, the court could no longer grant a request that had effectively already been granted. The appeal has been overtaken by events, the court ruled, and it didn't matter that he was moved to Sokoto Prison against his wish, or that the transfer happened just days ago. The court used that transfer as the eraser to wipe out the entire case, meaning by moving him, the government didn't just punish him, they killed his lawsuit. The most painful moment in court came when KANU's own lawyer, Barrister Maxwell Opara, was put in a corner by the justices who asked him to confirm the whereabouts of his client. Opara had to stand up and confirm, "My lord, he is currently at the Sokoto Correctional Center." And with those words, the trap snapped shut because the court used that confirmation to validate their decision. They held that since KANU had expressed a preference for prison custody over the DSS, and he was now in a prison in Sokoto, his desire had been met and the case was struck out. Imagine the irony of a man who fought for years to leave the DSS because he was being tortured, only to get moved to a maximum security prison in bandit-ravaged Sokoto to serve a life sentence, and the court calls that getting his wish. Now, let's talk about what the court refused to look at, because by calling the case academic, the judiciary has effectively buried the file containing horrific details of what happened inside the DSS headquarters between 2021 and 2025. We need to remind ourselves of the torture the headline talks about, because this wasn't just about being locked up. KANU's legal team filed affidavits detailing how he was kept in solitary confinement for 23 hours a day, forced to sleep with a bright light on which messed with his circadian rhythm in a known torture technique called sleep deprivation. They detailed how he was denied access to his own doctors, despite a serious heart condition and low potassium levels that threatened his life, claiming the DSS brought quack doctors to treat him and put his health in even more danger. There were reports that he was prevented from changing his clothes for months, forcing us to recall the days when he appeared in court wearing the same Fendi outfit over and over again, which wasn't a fashion choice, but an alleged humiliation tactic. He was denied the right to practice his religion, denied private moments with his lawyers, with agents listening in on every conversation and seizing documents. And all of these allegations, the starvation, the psychological torture, the medical neglect, were part of this suite with the goal to have the court declare them illegal and punish the DSS. But with today's ruling, the DSS has walked away scot-free with no apology, no compensation, and no accountability because the court says he is gone now, so let's forget what happened. This reveals the dark brilliance of the government's strategy because by rushing the conviction on November 20 and immediately moving him to Sokoto on November 28 and another 31st, they didn't just secure a prisoner, they dismantled his legal defense. If he had remained in DSS custody for one more week, the appeal court would have been forced to hear the merits of the torture case and rule on whether the DSS violated his rights. But by moving him, they rendered the case moot. It is a technical knockout where the government used the speed of the transfer to outmaneuver the slow wheels of justice, leaving NNAMDI KANU sitting in Sokoto carrying the scars of his time in the DSS, but with no legal avenue left to hold them responsible for those scars. This brings us to the question that is burning in the hearts of millions today. Is justice about technicalities, or is it about truth? If a man is beaten in a police station and then moved to a prison, does the beating stop being a crime? According to this ruling, the answer seems to be yes, or at least it stops being a priority for the court. This judgment sends a terrifying message to security agencies that you can violate a suspect's rights as much as you want, as long as you convict him and move him before the human rights case is heard, creating a license for impunity. Civil society groups and human rights organizations are stunned, asking how a court can close its eyes to past violations just because the victim's location has changed, setting a precedent that the condition of detention is only relevant while you are there, and once you leave, the abuse is forgiven. And where is the international outcry? We have heard about the US designating Nigeria a country of particular concern. But on this specific legal travesty, the world is quiet because NNAMDI KANU is now a convict, a label that changes how the world sees him and makes it harder for the UN or the UK to intervene. The Nigerian government knows this and has wrapped their actions in the cloak of judicial process, saying it was the court that sentenced him and dismissed his suit. But we know that the court works with the facts presented to it, and the facts were manipulated by the timing of the transfer. So NNAMDI KANU is in Sokoto, the human rights suit is dead, the DSS has wiped its hands clean, and the only battle left is the appeal against the life sentence itself. But for the 4 years of alleged torture, for the solitary confinement, for the starvation, there will be no judgment day in a Nigerian court because the academic ruling has taught us a hard lesson. In the game of power, the state always holds the ace card. What do you think? Did the appeal court fail NNAMDI KANU, or were they just following the strict letter of the law? And does this ruling mean the DSS is above the law? Let me know your thoughts in the comments because we need to keep talking about this since silence is the enemy of justice.